Hello, my name is Matthew Galuzzo. I'm a criminal defense attorney with the law firm of Galuzzo and Johnson LLP in New York City. This presentation is about state laws in New York regarding conspiracies to commit crimes. Obviously, there are federal laws regarding conspiracies as well, but this presentation focuses entirely upon the New York state level criminal statutes, which are contained in New York Penal Law Chapter 105. To begin, in New York State criminal law, conspiracy charges come in 6 different degrees. The most serious charge is conspiracy in the first degree. That is a Class A1 felony. The least serious charge is conspiracy in the 6th degree, and that is a Class B misdemeanor. Now, each of the 6 degrees, each of these charges has a very specific definition with unique elements, but there are some elements that are common to all conspiracy charges under New York State law. First, a person is guilty of conspiracy when, with intent that criminal conduct be performed, he or she agrees with one or more other persons to engage in or cause the performance of said criminal conduct. Also, a person shall not be convicted of conspiracy unless an overt act is alleged and proved to have been committed by at least one of the conspirators in furtherance of the conspiracy. So what does this all mean? Basically, what it means is that you could be guilty of conspiracy if all you agreed to do was commit a crime in the future. Take, for example, a case in which 2 people agree that they're going to murder somebody with a gun. And one of those people goes out and actually buys the gun, which would be considered an overt act in furtherance of this conspiracy to commit murder. But before the murder actually happens, both these people are arrested. Well, assuming the prosecution could prove that these 2 people agreed to eventually commit a murder, and that this gun was in fact purchased in furtherance of that plan, then both of these individuals could be convicted of conspiracy to commit murder, a Class A felony. So, as it says down at the bottom, you should note that no one was actually murdered in that example, but both defendants are nevertheless still guilty of this very serious conspiracy charge. Conspiracies can be proven in a number of ways, and typically are the result of long-term investigations. The first and most common way to prove a conspiracy is through the assistance of a cooperating witness or an informant. Another way to prove a conspiracy is by having undercover officers act as co-conspirators, so that when the trial comes around, these undercover officers can testify about the agreements that they may have overheard other defendants make. Another way that conspiracies can be proven is through the use of wiretaps. If you can actually get a recording of 2 people agreeing to commit a crime, that's obviously very powerful evidence for the prosecution. Some conspiracies are so careless that they actually make publicly available comments to each other over social media that can be used against them via Facebook, Twitter, or MySpace. Also, emails and text messages are being increasingly used to prove conspiracies between people and can sometimes be taken from cell phones that are seized pursuant to a search warrant. And lastly, sometimes gang affiliations can be used to demonstrate conspiracies between individuals. Now, the least serious conspiracy charge is conspiracy in the 6th degree under Penal Law Section 105.00. A person is guilty of conspiracy in the 6th degree when, with intent that conduct constituting a crime be performed, he agrees with one or more persons to engage in or cause the performance of such conduct. Now, this is a Class B misdemeanor, and one example would be if 2 people agreed to, say, shoplift a store together, and then they committed some act in furtherance of that shoplifting. Now, shoplifting is typically a Class A misdemeanor, but an agreement between 2 people to shoplift and some act in furtherance of that plan would be a Class B misdemeanor of conspiracy in the 6th degree. The next most serious conspiracy charge is conspiracy in the 5th degree under Penal Law Section 105.05. A person is guilty of this charge when, with intent that conduct constituting either a felony be performed, he agrees with one or more persons to engage in or cause the performance of such conduct, or 2, a crime be performed, he, being over 18 years of age, agrees with one or more persons under 16 years of age to engage in or cause the performance of such conduct. Now, this charge is a Class A misdemeanor. Now, just 2 interesting things to notice about this. Under the first subsection, subsection 1, you'll note that these people have agreed under this charge to perform a felony, but as a result of that, they are guilty of a misdemeanor. So what they're actually being charged with is less serious than what they planned to do. And under subsection 2, you'll see this reoccurring in future conspiracy charges, 4th degree, 3rd degree, 2nd degree. You see sort of an aggravating penalty for people who are over the age of 18 conspiring with people under the age of 16. Those older people get charged with a more serious crime for basically roping younger people into the criminal conspiracy. The next most serious conspiracy charge is conspiracy in the 4th degree under Penal Law 105.10. A person is guilty of this charge when, with intent that conduct constituting a Class B or Class C felony be performed, he or she agrees with one or more persons to engage in or cause the performance of such conduct. Now this would be a Class E felony. So again, you're seeing that the conspiracy to commit a B or C class felony is a slightly less serious charge, a Class E felony. Now another way to be guilty of conspiracy in the 4th degree is when, with intent that conduct constituting a felony be performed, he or she, being 18 years of age, agrees with one or more persons under the age of 16 to engage in or cause the performance of such conduct. So just like the prior charge, conspiracy in the 5th degree, there is an aggravating penalty for a person over the age of 18 engaging in a conspiracy with somebody younger than the age of 16. The final way to be guilty of conspiracy in the 4th degree is when, with intent that conduct constituting the felony of money laundering in the 3rd degree, as defined in section 470.10 of this chapter, be performed, he or she agrees with one or more persons to engage in or cause the performance of such conduct. Now, money laundering in the 3rd degree is a very complicated charge, and that is really going to be the subject of another presentation by itself. The next charge of conspiracy is conspiracy in the 3rd degree under Penal Law 105.13. A person is guilty of this charge when, with intent that conduct constituting a Class B or Class C felony be performed, he, being over 18 years of age, agrees with one or more persons under 16 years of age to engage in or cause the performance of such conduct. This charge, conspiracy in the 3rd degree, is a Class D felony. Now, an example of a Class B felony that is commonly charged in conspiracy in the 3rd degree would be selling drugs. 220.16, 220.39. These are some of these subsections of the penal law that are oftentimes referred to in conspiracy in the 3rd degree charges. The next most serious conspiracy charge is conspiracy in the 2nd degree under Penal Law section 105.15. A person is guilty of this charge when, with intent that conduct constituting a Class A felony be performed, he agrees with one or more persons to engage in or cause the performance of such conduct. Now, this charge is a Class B felony. Now, you may be asking, what are the Class A felonies? Well, these are the most serious felonies on the books. So as you might imagine, these are things like homicide, drug dealing on a very large scale, very serious kidnappings, arson-type charges in which people are hurt, terrorism, and sexual assault of children. These are some Class A felonies. The final and most serious conspiracy charge is conspiracy in the 1st degree under Penal Law section 105.17. Now, this charge is identical to the prior one, conspiracy in the 2nd degree, except for one different element, which is an element we've seen before in other conspiracy charges, which is to say it's more serious when a person over the age of 18 years agrees with one or more persons under the age of 16 years to engage, again, in a Class A felony. And as I said before, some of those Class A felonies are things like homicide, serious arson, large-scale drug trafficking, kidnapping, terrorism, and sexual assault of children are just some of the examples of Class A felonies. If you or a loved one have been arrested or indicted or are being investigated for a conspiracy charge, you should very strongly consider contacting the experienced criminal defense attorneys at Galuzzo and Johnson LLP for a consultation and free case evaluation.